Jina yangu naitwa Nora Bahati Sabaya, mimi ni mkazi wa Malindi Airport kwa Chocha na ni muathirika wa Airport kwa Chocha. Pamoja na hao wenzangu wote tumeathirika kwa ile shamba. Na sasa tumetoka pale, si tunajua kitu kimoja, tuliambiwa na court tutalipwa pesa zetu kifika Disemba tarehe 11 kile mtu atakuwa shalipwa. Kwa hivyo sisi tumesema ikifika tarehe Disemba tarehe 11 hatujalipwa pesa, tunarudi kwa mashamba yetu. Narudi, hata mimi narudi kwa mashamba, tunarudi.
Mimi dama nimechokana na mambo ya airport. Manake hapo nilipo sina la kufanya tena. Hapo nilipo hata ni mjani, bwanangu ameniwacha, sina mwingine wa kunitetea. Ninataka hizo pesa zangu nipate mahali kwa kukaa. Nimechoka na kunanganyika, nimechoka na kusumbuka. Tafadhalini serikali ituangalie tupate kulipwa pesa zetu.
Tukaja pia tukapata issue nyingine ambayo inaendelea. Kuna hiyo Adani group ambayo imeingia. Hiyo Adani nasikia na take over hiyo airport kuanzia mwezi ujao pengine. Sasa wasiwasi wetu ni kwamba je, hii Adani napokwenda kuchukua hii airport sisi tutakuwa namna gani? Tuko hapo kotini kwa sababu tunaje kuomba koti iweze kuingilia kati tena, iweze kutuambia kama Adani itachukua hiyo airport, hatima yetu sisi kama wakazi wa kwa Chocha ambao tumesubiria hiyo miaka 15 tuweze kulipwa na hawa watu wa airport, hatima yetu itakuwa nini? Kwa hivyo kupitia wakili wetu tumeomba hizo orders, na ni kama watu wa airport bado hawajaweza kutujibu kama either Adani ikichukua itachukua na sisi pamoja, ama Adani ikichukua itakuwa ndio imeisha hivyo. Kama hakutakuwa na mwafaka wa kueleweka, maana tumeona tayari mpaka sasa they are buying time, wanazidi kuchukua muda, wanadanganya kila siku. Inquiry ambayo itafanyika mpaka sasa haijafanyika. Sisi kufikia tarehe 11 mwezi wa Disemba, kama hakuja kuwa na mwelekeo, sisi tutarudia mashamba yetu.
The only fear we have is that in December we will find new management. The owner let the respondent maintain his legal position until my clients are fully compensated. You have been in court for the past 15 years. That is all.
Yes, my name is Mr. Mogaka. I practice in name and style of Mogaka Bongaki and Company Advocates. I am on record for the applicants. Today we sought temporary orders restraining the takeover of KAA, that is Kenya Airports Authority, and I am confident that the court will grant us the orders because there is no defense which they can come up with, which we have not seen. There is no documents they are going to bring. We have seen all documents because we've been in different courts. There are several matters pending before the National Land Acquisition Tribunal, and we won the case. And we came here under a miscellaneous application number 41 of 2024, purely to get temporary orders for stay, because we are asking what is the hurry of the takeover? How do you acquire land for 15 years? The law stipulates very well that acquisition has to be completed within a year. This we are doing the 15th year, but they are still seeking more time. We believe we are coming back on 12th, and the court will grant us the orders. That is all. Yes.
In respect of the motion before me, brought by Mr. Mogaka on behalf of the applicants, they are as follows. This matter came up before this court on 8th of October 2024, and this court, upon noting the gravity of some of the prayers sought by Mr. Mogaka's clients, ordered service of the motion dated 2nd of October 2024 on the respondent. The purpose of that order was to grant the respondent time to respond to the motion within that period provided. This court was of the view that sufficient time had been provided and that a response would be lodged timeously to enable a hearing of the prayers number 4, 5, and 6 today. but the respondent has not filed any documents to date. Mr. Adoj states that he is still in the process of seeking instructions from his clients. He also states that there is other litigation central to which the issue of management of the respondent is in other courts. This court has not been properly appraised of the full content of any such litigation by the applicants herein, and it will be only prudent for it first to have a glimpse of the sort of litigation before the other courts, now that it has been mentioned, to enable it to distinguish it from the present litigation. This would enable this court to decipher whether or not the doctrines of res sub judice and res judicata espoused in sections 6 and 7 of the Civil Procedure Act can come into play in this matter. It is only just that a respondent be granted a hearing when serious orders are sought against it. Now that the respondent has not filed any response but is represented by counsel today, what should this court do? Noting the seriousness of the order sought, this court must exercise its discretion in favor of abundant caution and adjourn this hearing to another date so that a response may be filed. However, that period cannot be as long as proposed by Mr. Adoj for the respondent, since I have been informed that the applicants have been waiting for compensation for more than 10 years. Consequently, I adjourn this hearing and I order as follows. Number 1, Mr. Adoj shall file the response of his client, the Kenya Airports Authority, to the motion with respect to prayers number 4, number 5, and number 6 within 10 days of this order, not 21 days, Mr. Adoj. Mr. Mogaka shall have leave to file a supplementary affidavit in response thereto within 4 days of service of Mr. Adoj's response, or in any event file such affidavit and serve, if necessary, within 14 days from today. The application shall be listed for hearing on 12th of November 2024 in respect of prayers number 4, 5, and 6, and a ruling date shall be set on that day. Directions on the rest of the prayers will be given in that ruling. All parties present shall be at liberty to file skeleton submissions and serve them on their counterparts before the hearing date of 12th of November 2024. Those are the orders of this court. Butra, Mr. Adoj, Mr. Adani,